looking at principles of professional practice for barristers and solicitors. At the end, we'll also have a look at a disciplinary decision involving a solicitor and to see what sort of things happen when you run foul of the rules. And finally, I'll sound a note of caution for both if you're intending to be a barrister, what you should be looking at now, and if you're intending to be a trainee solicitor, some points to note and be careful of. Now, a lot of this subject is avoiding risk, avoiding danger. So I'll be giving you some pointers. But just and to let you know, we'll have a break at about 10:30 for about 15 minutes. So and then we'll resume something like 10:45. And okay, let's start with me telling you about the course. And I want you to understand that I know that some of you are going to be barristers, some are going to be solicitors. What we'll be doing, this course is heavily based on the Solicitor's Guide to Professional Conduct and also the Code of Conduct for the Hong Kong Bar. So I presume, am I right, that you now have hard copies of the guide? You have that yet? No? Well, the Law Society will be providing them free of charge. Okay? Hard copies of the Solicitor's Guide. If you haven't got that yet, I know we've asked for them, we've given them the number that we want. In that case, go online to the Law Society's website and you can get it there online. It's part 1 of the guide. Okay, so that's a very important document. The other is, it's not issued, I don't think, in the hard copy form, but is the Code of Conduct for the Bar. And you need to get that by going onto the Bar Association's website and click About Us. And then under that you'll see it says the Hong Kong Code. Okay, so that's where you find both of those. And what I can tell you is it's important that you actually read each of those publications cover to cover at some stage. The earlier, the better. I know it's not the most exciting reading that you can look at, but it will help you enormously if you have actually read it. That's both the code and the guide. Because although in the SGSs we do have study of practical problems which will bring up provisions of the guide, will bring up provisions of the code, it's much better if you've actually read the whole thing. The other thing I'd like to say is, do we have an emphasis more on the solicitor's branch of the profession than the bar? We do. And we're quite open about this, and I'll tell you the reasons why. We focus more on the guide because two main reasons. Number one, most of you are going to become solicitors. Usually every year it's about 90% or more intend to join the solicitor's branch of the profession. So there's that argument. But we still teach the code as well. We're not leaving the barristers, the intended barristers, out. But the second matter is barristers compulsorily have to study the Code of Conduct after they enter pupillage under their advanced legal education. So you'll study it anyway. Solicitors will not. Trainee solicitors will not. So there's potentially a gap there. And you'll find that when you're in your firm, you're busy with learning the practical aspects of the job, you may not have time to set aside some hours to read the guide and become familiar with it. Some people say, well, why do we bother with the code? The barristers are going to study it anyway. Let them get on with their end of the business. why bother? Why should solicitors study the code? But it is important. We work together. The system is that barristers and solicitors complement each other. And if you're instructing barristers, it's only right that you know what professional constraints they work under. You will find that you get briefs that you've given out to barristers being returned to you. And the barrister that you wanted to represent your client says to you, "I'm sorry, I cannot do your client's case. My present case is overrunning." So you'll have to say, "Well, okay, did he give me reasonable notice? Is this at the earliest opportunity?" But we have to accept that briefs are accepted by barristers on the basis that they may have to return them if they have a pressing court engagement that they can't get out of. But there again, if your barrister says, "I'm returning this brief because I've decided to go on holiday and not do your client's case," you may feel like you want to bring to him or her, "Sorry, that's not right. I'm going to bring your attention to certain provisions of the Bar Code which say you should not return a brief for such a trivial reason." So it's important that we solicitors know the rules that our fellow lawyers, the other branch of the profession, work under. Okay, I would say the LGSs, what we're doing today, there's going to be 6 of them on this part of the course. After that, after my part is finished, you'll be going on to solicitors' accounts, understanding financial statements. Now, every year I get people saying, "Why do we have to study accounts? We're lawyers, we're not accountants. We're word people, we're not numbers people." Well, I think if you study first, we do the first part of this course, and we look at professional conduct. We look at what is expected of barristers and solicitors. Then I hope you will conclude that it's absolutely right that solicitors should understand that they can't borrow or take the client's money. It's not theirs. We have separate rules for client's money and the firm's money. When I was doing the equivalent of what you're doing, I didn't like accounts because I couldn't understand them, basically. I went on a very small crash course. Never understood double entry bookkeeping. But one thing I did understand. I passed the exam. It was the one I was really worried about not getting through. But I understood that once I got that qualification, it's very difficult for me to say if I've taken the client's money. That, well, I don't understand accounts. It's just a mistake, that I took a few $100,000 from the client's account to settle my gambling debts. It's not going to wash. Okay? You're fixed with knowledge. If you can't do the accounts, you get someone who can, and that's what most firms do. But the buck stops with the solicitor. If you know about accounts, you better make sure that everything is followed in your firm. So, that having been said, the logic is we look at professional conduct first, and then we go on to the accounts. Bear in mind that sometimes I've had students, intelligent students, have said to me, I don't think this subject is important, professional conduct. It's all a matter of common sense. Why do we need to study it? Well, I would respectfully disagree. It's not just a matter of common sense. We do have to study the code. We do have to study the guide. We have to understand that we're now looking at life from the perspective of being a legal professional. All the obligations that flow from that. Someone last Tuesday, just gone, asked Mr. Harris a very intelligent question. What should you do if you're representing someone accused of a crime and he confesses he's guilty. I don't think the answer to that is obviously simple to be a matter of common sense. It requires a knowledge of the underlying principles under which we operate, and it would also require a knowledge of the relevant provisions in the Bar Code of Conduct, which we'll look at. Another thing is, if it's common sense, you're in your solicitor's office, you're a trainee, you're involved in litigation, civil litigation. You're standing next to the fax machine. They still have them, I think, in firms. And out comes a fax. And it's from your opponent in this bitterly contested litigation. And it's been clearly sent by mistake to you, because it's addressed to the counsel who's advising them. And it's discussing possible settlement, their strengths in the case, their weaknesses. Common sense might suggest, crikey, I'll read this and we'll make use of it. I'll get an advantage here for my client. The answer professionally is actually something quite different, which we'll be studying, what you should do in that situation. And it happens. It happens more often than you think. There were you, standing next to the fax machine, having a cup of coffee, not expecting anything, and all of a sudden, you're faced with a professional conduct problem that you never anticipated when you went to work that morning. You better have some background knowledge in order to deal with that situation. Common sense by itself, whilst important, will not answer your questions as to what you should do. So it's a very important subject that we're studying. Very important. And part of my strategy to impress on you how important it is that in week 6, we will have a guest speaker. Not on week 1, I decided it's better to have for this subject a guest speaker on week 6. So you listen to what this person says about professional conduct and whether he thinks it's important. So it's going to be Mr. Justice Frank Stock of the Court of Final Appeal. He's a non-permanent judge. And he's very kindly agreed to give his time to come down here and tell you some thoughts that he has about the importance of professional conduct for lawyers. So you can look him up, you'll see how he was in charge of before going to the Court of Final Appeal, how he was in charge of the criminal division of the Court of Appeal for many years. How before that he was a judge and he was very high up in the Department of Justice, in the Attorney General's chambers as it was then. Okay, so mark that date for your diary, week 6. We'll be having that guest talk. So these are the LGSs. As I say to you, it's important. I'll go through provisions of the guide that I think are important and perhaps are most likely these issues are going to confront you in the early years of your being a professional. So it's important to attend. It's important to attend on time. Incidentally, I know people think this is a pet subject of mine, but if you actually read the Code of Conduct of the Bar, barristers, when you are now a pupil barrister and you go to advanced legal education, if you're late, they lock you out, even though you paid for the course. The Law Society, a bit different. They say, oh, you can come in, but you won't get any CPD points. So you can sit there, but it's a waste of, you've got to collect so many points, right, during each year of your traineeship and afterwards. I still have to get points. Okay, so the professions are a bit more strict than we are. Okay, I don't take offence if you come late to these things, but it is important to be on time. It's in the code, and it's an important thing as far as the Law Society is concerned. I've said to you before that the small groups are very important, and they are in this subject. And I'll just tell you a little bit about the small groups. It's important to attend. It's important to attend on time so you can help yourself and your fellow students. And it's important that you participate. I really mean this. The SGSs work like this. First, we have problem solving, different problems, whereby you're asked to say, well, what is the issue here, and how, as professionals, should we try and deal with this? If you are in a firm or if you're in chambers and you're presented with a problem of professional conduct, I strongly advise that you think about first what you should do, and then go and talk to someone else, probably someone more senior, because a problem shared is often a problem defeated. Right? So it's quite important. You will do that naturally, I assure you, because you don't want to end up with anything bad against your name. So you'll go and probably talk to your principal, a senior partner, and say, look, this has happened. I think I should do this, but I want your views, please. The same applies in the small groups. It's important that you prepare for the small groups, and then you'll be split into subgroups, like 2 or 3 students, to work on one particular problem. And the 3 of you or the 2 of you try and come up with what you say is the solution. And that is discussed with the rest of the group. Very important that you do that. You'll be learning, and people will be learning from your reasoning. If you get it wrong, great. They learn from your mistake. Don't be worried about making that mistake. So participate in the small groups. It's very important. But that's only part of the story. The other thing that we introduced some years ago was that we also require you to make presentations to the rest of the group. So you'll be divided on the first SGS. You'll be told, right, who would you like to do a presentation with for this particular case? This case involves someone being deemed not to be a fit and proper person as a barrister. Who would like to do this case? This is a solicitor and a trainee who loused up making a will. Or who would like to do this case? This is a solicitor who has been classed as a disgrace to the profession. Who would like to do that? Okay? Now, it's great fun actually doing the presentations. You work together, and over the years the standard has been impressive. And you're given a large amount of freedom as to how you do it. I think we normally say, could you make it 15 to 20 minutes, something like that. But you decide the content, and that your teacher will give you some constructive feedback. But make sure you put effort into the presentations. Occasionally we've had people who try to wing it by not having read the case. It's disgraceful. Okay, so please put in an effort, but enjoy it. It's great to have a chance of standing up and doing a presentation. It's a bit nerve-wracking, but the second time won't be quite so nerve-wracking, and it prepares you for when you have to do it in your jobs. Okay. So, what else do we have? Yes. So sometimes the LGSs are not all of uniform length. Sometimes we finish a bit earlier than planned. If that happens, if you haven't prepared yet for the small group, go away and prepare for it. Okay? Read the materials, look up the code, look up the guide. Okay. Now, Mr. Harris, when he was here the other day, he, I think, expressed the views that I feel when we're talking about professional conduct. He said, I'm not here to preach to you, or words to that effect. I'm not here to preach morality, okay? Your morality, I'm sure, is as good as mine, probably better, okay? But the subject is important of professional conduct. We can't get away from it. It's better that we confront a problem that's in the news today and that we consider what are the implications for this case. I have not read this story in the English press. I've only been told an interpretation of what has appeared this morning in the Ming Pao newspaper. I'm sure it's in all the other newspapers. But this concerns an ex-student, JD student from the Chinese university. You read about that? Okay, well, we have a bit of a laugh and we say, yeah. But let's just think about it. Well, I don't know this person. I may have taught her, I don't know. But you may have read about it. I don't do landlord. I'm glad it's got your attention. Just a moment. You correct me if I'm wrong on the facts. You correct me if I'm wrong on the facts. Because it's one of the admin staff said, hey, do you know about this case? And of course, the Morning Post is not so fast as the Apple Daily. Probably a little bit more accurate sometimes, but anyway. So I'm saying what I've been told this morning when I arrived early. And I was told it's an ex-JD student of the Chinese University of Hong Kong, Faculty of Law, and she's a 2013 graduate. So I started teaching in 2012, probably missed her because I was teaching criminal law then. Maybe she'd already done criminal law. Apparently, in August 2013, she went to the Taipo government offices and saying what she said was a JD transcript, original, and goes to this officer, government officer, and asks him or her to make a certified copy, something that solicitors do day in, day out. A certified copy of an original document. You will think, how could that ever bother me? I make a certified copy. So, he makes the student takes away the certified copy of the transcript. The officer, no doubt, presumes in good faith that he's giving me an original, unaltered document. That's what you would expect. And then apparently there were some differences between the document she had certified and the actual record of the graduate school. In fact, 18 courses that she'd taken, the grades were different on the document that she was producing to the university's record. 18. Okay? Where in actual fact she had a GP of 2.49, in fact. Okay? But now on the documents it's 3.46. People say, that'll get you into PCLL. No margin for error there, well in. And it also happened to do a demerit had been mysteriously deleted, which of course was not obvious from the document that was presented to the government officer. Of course, she didn't apply here to PCLL. Apparently, she applied to Hong Kong U. Right? Wonder why. Okay, so there we are, and she was admitted to the PCLL, and she said she had a pass in land law. You were correct, you got that right, and she attached her certified copy of an original transcript to her application. It seems that GPA of 3.46 didn't hold up too well in reality because she failed first year PCLL exams and had to take a retake, which she failed again, and needed to take some special supplementary exams. Apparently, she dropped out of the PCLL in August 2015, not having completed and passed the course. So there we go, failure. But in June, she emailed to a partner of a solicitor's firm, applying for a trainee contract, attached her JD certificate, the one that she had certified, the certified copy, And she was subsequently submitted a PCLL certificate. I hate this, but the Americans do it. Issued by Hong Kong University. And she got the job. Everything seems to be going well, right? But there's a little thing here. You see, there's more than one organisation involved, and she needs to apply to register her trainee contract. Who with? The Law Society of Hong Kong. And she submitted her papers, and the Law Society found out that her name was not on the list provided by Hong Kong U for people who had passed the PCLL. Hear alarm bell ringing in the corridor. Law Society must have then leapt into action. Inquiries were then made with the Chinese University and Hong Kong U apparently, and it became clear that documents that were not correct, documents that were forgeries, had been used. Where are we moving now? This is going beyond professional conduct. This is going into the realms of the criminal. The boys in blue and the girls in blue are now getting involved. Okay, so the police become involved. I think it's the police, and in December 2015, the Law Society informed the firm about. They thought there's an apparent odd situation. She's got a trainee contract there, and she's not registered. She doesn't appear on the list of Hong Kong U graduates and the PCLL, and apparently the information that she's reported to give to Hong Kong U doesn't match with what Chinese U has. Where does it all end up? We don't know yet. Police interviewed the partners of the firm, and I understand that yesterday she appeared down in Wanshai at the district court. Question: what does that imply to you as lawyers if she's down at the district court?
At least 2 years.
Why at least 2 years?
Because it's over the course.
The guest speaker revealed the other day that normally, not in all cases, but normally the maximum sentence that the magistrate can pass is limited to 2 years. District court? 7. Okay, that doesn't mean she's going to get 7 years. I understand she's admittedly guilty. But obviously the Department of Justice think it's a real possibility that the tribunal could be thinking of a sentence of more than 2 years. So she's been remanded, and we will see the result. I'll post it up when we have it on the materials, so you know about it. But I want you to think about several things. How would you feel if you're the government officer and the policeman is knocking at your office door saying, "Afternoon, sir, I want to work with you. I want you to help me clarify something." Now, he's not a suspect yet, but potentially the police want to know, why did you certify this document? What document did you certify? Not very pleasant, believe me. Even though the police, I'm sure, are very polite, but in your position, I would hate that. I'm doing an honest job, and now I've got involved in making statements to the police. I probably have to go to court. I'll probably have to try and justify what I did on that day. I had no reason to suspect it was a forgery. Right? You're under the spotlight. Imagine how the partners of the firm feel. Police knocking on their door. I want to get on with my work. Excuse me, sir. I want a statement from you now about how this person applied for a job. And you've got to spend hours making a statement. And again, you're thinking, did I do anything wrong? My behaviour is now under the spotlight. I may have to give evidence in court. I'll have a defence counsel trying to perhaps cast my motives into doubt, that I didn't act properly. And this goes on for months and months and months, the waiting. Imagine yourselves, in 10 years' time, assuming that she's pleaded guilty, she doesn't appeal the conviction, you're now solicitors. And solicitors of 10 years, near enough standing, and you do work for the Law Society. You put yourself forward to help out on committees. That's what we should do. And well, just imagine if you're on the committee that now decides she's reapplying to be a solicitor, to take up articles. Fit and proper person? You're entrusted with the responsibility of making sure that we keep the bad people out of the profession, because bad people in the profession have stolen the client's money in the past. Bad people in the profession have caused losses to all the other solicitors who have to chip in through insurance. Are you going to take the risk? I'm sure it's a hypothetical question, I'm sure you would follow the rules, the requisite considerations. But it's going to be some brave person who says, I think, fit and proper person, given that record. So that is just an object lesson. I'm glad it came up today. And I suppose ask yourselves, do we like it? When people say, when we go to the bar tonight, or we go with friends, hey, I saw someone from your faculty, ex-faculty, was in trouble today. We don't really like it, even though it's not directly against us. We don't want too much of that. Okay. So anyway, it's an important matter. Now, of course, this is exceptional. Most people who end up in professional conduct situations actually never intended to get in that situation. This, it appears, was premeditated, very deliberate, carried on over a great period of time. But we'll be looking in a moment about a case that doesn't involve any premeditated wrongdoing, but still had profound implications for all involved. But what I want to tell you briefly is the teachers, before I start, I won't say very long. You know me, I've been a solicitor since 1981 in Hong Kong and in England and Wales. I only practiced in England and Wales for a short time before coming to Hong Kong. And I've had my share of looking at having to decide professional conduct problems as a senior partner. You have to decide what is the correct thing to do in this situation. But the answer is not always very clear. You have to feel your way sometimes. The exam, I've mentioned to you, I think, that you've got to pass, if I haven't, you've got to pass professional conduct. That's what the Law Society says. No averaging out. Pick your 50% minimum. Go for more than that. Have a nice buffer of success. And you've got to pass solicitor's accounts. No averaging to pick up a bad mark. Okay? Now, sometimes, I've told you about the student who said this is all common sense. It's not. And from time to time, like last year, people fail this course at the first attempt. So don't treat it as if there's not much law here. It's easy. You need to concentrate. You need to do a fair amount of work. Besides me, we've got the Deputy Director, Queenie Bly. You're fortunate to have her. She won the Faculty's Teaching Excellence Award a couple of years ago, I think. Her background is very different from mine. She's City Firm, City Finance, Clifford Chance. Worked abroad, Hong Kong, London, Shanghai, international practice, and also was education training manager on stage for a particular firm. We've got Dennis Edwards, who's I think on a conference this week, but he's been a barrister for over 25 years, Commonwealth scholar, he's got LLM, barrister of the Middle Temple. I think he's written the book on judicial review in the UK, and he regularly contributes to Law Quarterly. And you've got also Mr. Mitchell Stocks, who's American, and he's practiced corporate and commercial law. And he's been teaching on PCLL and other places, I think, for over 6 years. So you've got a great spectrum of people teaching you. Okay, so let's get on with it now. We've got about 20 minutes before we have the break. Some simple stuff here. Codes of conduct, why are they important? Well, you'll even see that they're important for things like trades. they will often, trades, we're not a trade, but trades, different things, boiler makers or plumbers, things like that, will often have some sort of trade organisation and a code of conduct. Those that advertise, we subscribe to the code of conduct of the boiler makers or the plumbers organisation, and it reassures customers that there should be a minimum standard going on, okay, in that particular trade. But they're far more important for lawyers. It's more than simply a matter of self-interest and getting more business. But, having said that, if you look at self-interest, there's certainly a case for us in having codes, because why would people come to us, entrust with us their most serious problems that they probably never tell their spouse about, if they couldn't trust us? Why would they give us, deposit with us their money if they couldn't trust solicitors to deal with that money in the correct way? So there is a self-interest. But amongst the materials that I urge you to read, and what I do is, in this subject, I sometimes highlight the materials in yellow, put on blackboard. Please read the whole materials. I know what you're thinking. It doesn't mean that this is the only bit you have to read. Please read the whole, but please, I just suggest you pay particular attention to the highlighted bits, because it's making a point that I want to make. But here is from one of the materials. And it goes back to what I said I think on Saturday. We as individuals are no more important than anybody else. The person who was the corridor out here, or the person on the front desk. We're not. But the job we do, the job that we are entrusted with is important. And it's important in many societies. We have to have codes of conduct for lawyers to maintain confidence in lawyers and in the whole system. And I'd like you to read those articles, especially the bits highlighted, because you've got judges saying the system would collapse. The system would collapse if we didn't have codes of conduct by lawyers. One of the things we'll find is that lawyers are not meant to fan the flames of litigation, stir things up. We're meant to encourage settlements that are in our clients' interests. Can you imagine if we never kept clients' confidences? That we deliberately stoked up the litigation? Don't stand for that. Go on, fight the case. With no good reason. The whole system would be absolutely inundated with cases. It couldn't survive. So let's look at this. It's especially important. We need codes of ethical conduct to maintain confidence in lawyers as well as the legal system. Legal work is always important to the client. If they're coming to you and paying their money to you, your firm, it means it's important for them. Even though it's a careless driving case, or even though you think it's a relatively minor matter, that they're coming to you in itself is a demonstration of how important they regard this matter. So, if we don't have integrity in the system, there will be no system. Same quotation going on. Our guest speaker on Tuesday said that the courts trust you, but once you abuse that trust, it's gone forever. You've blown it. Go and do something else. Become a salesman or anything else, because the bad news travels faster than any good news. The judges talk about people that appear before them, and those that mislead are known. So even though you're fighting in bitter litigation for a client in court, you still have a responsibility to honestly assist the court, state what the law is, state what the facts are when called upon. That includes mentioning cases that are actually against your client's case. That's not common sense, or obviously common sense. Those quotations come from this guide, which was put together by the English Bar to try and assist developing countries when they're building up their legal system. They want a code of conduct for their barristers. Perhaps it's a small impoverished state somewhere in the world. They could rely on this because it is of general application to civilized societies. So, bear in mind this trust matter is extremely important. In Hong Kong, we've had these observations. This is from Mr. Justice Kevin Zervos. He is also a regular guest speaker with Chinese University of Hong Kong. He normally comes along and speaks on the trial advocacy course in the summer. He gives us a talk. This is from one of his judgments. He's acknowledging the important role that solicitors play in society and generally the trust that Hong Kong society has placed in the legal profession. That includes barristers. So it's important that the Law Society properly and fairly discharges its regulatory function and its disciplinary function. So here we have it. The solicitors, although we're officers of the court, it is going to be the Law Society that may well end up in investigating any alleged misconduct. It is the Solicitors Disciplinary Tribunal normally that will deal with misconduct in their proceedings. It can get to the courts if there's an appeal against the Solicitors Disciplinary Tribunal. So, for solicitors, it's going to be the Law Society that are going to be enforcing professional discipline. If we move on, this is not from Mr. Justice Zervos, this is purely homespun from me. But I would say that as a broad approach, this should help you. When you're confronted with a situation, work out what is the correct thing to do, in as much as you can work it out. So you'll start from general principles that we'll talk about later, and then more detailed provisions of the guide. Perhaps we can look at cases in the past. Try and find out what is the right thing to do in this case. And then, second, follow it. But equally important is always, always be in a position to prove to people that you did the right thing. And this goes back to what I said in an earlier lecture. You must get into a habit when you're in practice of making file notes, what you've done, because your behaviour may come under the microscope years later. You will not remember what you did. And where necessary, if it's, say, giving advice to a client, you do it in a letter. It's been sent to the client. Why? Why would you do that? Why would you? I'll do the file note, but I'll also put my advice in a letter. Why would you do that? Any idea? Belt and braces. You know, they say for safe people, they wear belt and braces. It's evidence of what I've done, evidence of what I told them. Excellent. And if you accuse me of forging the file note after the trouble came up, sorry, it won't wash. I didn't forge anything. I didn't forge this letter. It's got the date on it. Okay? So that's one of the ways you have to protect yourself. Always be in a position where when things come under the spotlight, when you get that uneasy feeling, everything I've done now is being examined. You're able to show you did everything that you were expected to do. Now, you'll have a case to study where you'll say, well, this lawyer set out to do some pretty bad things. We had this morning's example, but believe me, most people involved in a professional conduct situation, a problem, never intended or anticipated that they would be facing such a problem. It's sometimes you suddenly think, crikey, I'm in this situation. I never intended to get there. And this is one of the biggest dangers, because the vast majority of solicitors do not go about deliberately breaking the law or breaking the professional codes. But it can happen to anybody. Now, I don't expect you will know this person, but if you look in the background, it looks a bit like a church. It's not. It's the Law Society's Hall in Chancery Lane, London. This gentleman was the president of the English and Wales Law Society. The head, the senior partner of the biggest personal injury firm at that time in the whole of England and Wales. Respected man. And looking at his story perhaps illustrates how you can get into a very unpleasant situation without necessarily intending it. And it's a Hong Kong story as well. There's a Hong Kong link to this. So what I'd like you to do when you have time is look at the materials, look at the report in the Guardian newspaper, which deals with his particular situation. There was a barrister in Hong Kong called Michael Ford. I didn't know him personally, but I'd see him around the courts, usually the magistrates' court. And what happened was, he was in practice, there was an explosion one afternoon out at the Castle Peak Power Station in Hong Kong, near to China. We weren't in part of China. And 2 people were killed. 2 employees of the electricity company were killed in this explosion. And I think what happened, there was legal proceedings arising from the death, civil proceedings. And the company, I think it was then called China Light and Power, engaged solicitors, and the solicitors engaged Mr. Michael Ford to represent China Light and Power. And during the proceedings, Mr. Ford thought the documents that he was being given by his own client had somehow been altered. They were not telling the truth. And he actually went public with this. And normally you keep your client's affairs confidential, but he went public. The client, you can understand, would be naturally upset and sacked Mr. Ford. And subsequently you'll see there were civil proceedings against Mr. Ford by the China Light and Power Company for breach of confidence. They were seeking damages. The result was Mr. Ford left Hong Kong and gave up his practice. And the case didn't go very well for him. I'm simplifying, but he was losing, and he was going to the Privy Council because we didn't have the CFA then. It was pre-1997. We didn't have the Court of Final Appeal. So he went to the Privy Council, and he's run out of money to pay expensive lawyers' fees. And I don't know exactly how it came about, but here we have the president of the Law Society saying, well, my firm will represent you pro bono. What does pro bono mean? I hate using Latin.
Free of charge.
Free of charge. Actually, it's not free of charge, because it's costing the firm. If you think about it, it's costing time and money for them to do the representation, but it's free for the client. So, to cut a long story short, what then happened was it went to the Privy Council. Not entirely successful. Didn't go well. There was some victory for him, but on several key points he didn't win. And whenever you lose in litigation, you're bound to feel bad. But it then became clear Well, it was clear that China Light and Power actually were linked to a US corporation called the Exxon Corporation. And Mr. Ford found out that his firm were actually acting for Exxon in other matters. What do we call that, potentially? A conflict of interest. Now, Mr. Ford turns to be an accuser of the president of the Law Society. You have a conflict of interest. You sabotage my case. Now, I don't think anyone ever said he'd sabotaged the case, but there was a conflict of interest on the face of it, which was not good. To cut a long story short, the Law Society held an investigation in England and said, yes, there was a conflict of interest, but it didn't really affect matters. Did Mr. Ford give up? No. He complained, I think it's to the Solicitors Regulatory Authority, which is even above the Law Society, and they said, well, there were faults in this investigation by the English Law Society. We'll pass it to the Scottish Law Society for them, because they are completely not related to this person. And the Scottish Law Society, I think, criticised the English Law Society, said there was a conflict of interest. And then, a little bit of research for you, if you can find out what eventually happened. It seems then it went quiet after a while. But certainly, this gentleman was involved in injunction proceedings to try and stop the press saying that he was the subject of these disciplinary proceedings, and the disciplinary proceedings had not gone entirely well. So ask yourself, I don't know, did he go into that case intending to get involved in all of this investigation by the English Law Society, investigation by the Scottish Law Society? Dreadful publicity, damage to his reputation, the firm's reputation. I doubt it, but it happened. And if it can happen to him, it can happen to me, and it can happen to anybody else. So we do have to be careful. So what I'll do, we'll pause there and have our break. It's 5 minutes early. And then we'll move on to sort of, well, what are the standards expected of the average lawyer? And we'll then go on, do that, and look at some of the basic principles for barristers and solicitors. Okay, so let's come back at 22.
唔使啊，我頭先食咗，我唔知阿 BB 可以唔？